Can you hear me? Can you see me? Please,
We can hear you, sir.
can you see?
Yes, I can see you.
Okay. And the board also you can see, right?
Yes, sir.
Okay, right. Okay, then we'll start. We were discussing about the checks last day, and I think we stopped. At what point we stopped? Crossing we finished, no? Right.
We have finished checks. Checks we have completed, sir.
Right. So collection of checks. This slide that we have to start, no? We didn't discuss this one, no? Okay, we'll start from here. Right. Now we are discussing about the collection of checks, right? As a bank, when it comes to checks, we have a dual character as a bank, right? Bank, we say bank, we take a real bank, HNB, right? They have their customers, we say A, who is a current account holder, and he issues checks, we say B, who is a customer of commercial bank, who deposit the check to commercial bank, and commercial bank send a check. We send money to commercial bank, and commercial bank credit customer's account. So just forget about automated systems, right? We just think that it is the mechanism is this, that we send the check and the money credit to the bank, so then we pay the customer. So this is the process that we discuss, or we have to consider when it comes to a check. Our customer issue checks, those checks will be forwarded to the other banks, and those checks will be forwarded to us. We have to pay the checks on behalf of our customer. At the same time, our customer may receive checks from other people or his clients, then he will deposit his checks to our bank, right? And we collect checks for and on behalf of our customer. So as a bank, when we take this bank, it should be, we have a dual character. As a paying bank and also as a collecting bank. So these two characters that now we are going to discuss. What are the legal principles applied? What are the things that we have to be cautious, we have to be consider when we are collecting checks? What are the law principles applied? What is our liability as a bank when we are collecting checks? Those are the things that we are going to discuss under the collection of checks, right? Okay. Collecting bank is the bank who undertakes to collect the checks for the customer. So collecting, we are now consider ourselves here. We are collecting checks for our customer. The bank has no legal obligation to collect checks drawn on other banks. However, this is an extra service performed by every bank. Now, the question is this. As a bank, do we have a legal obligation to collect checks for our customer? Legal obligation means under the banker-customer relationship, if we have obligation, that means that we have to perform as a duty. as a duty. Principle is this: under the banker-customer relationship, if we allow a customer to open a a current account and a current account, that we are obliged to collect checks and pay checks on behalf of the customer. Legally, we are bound to collect checks of the same bank. For example, if we are HNB, we are legally bound to, listen very carefully, we are legally bound to collect checks received by our customer if those checks are HNB checks. Clear, everyone? You have any questions? Can you hear me? Do you agree with me? Can someone respond? Do you agree with me that as a bank, we have obligation, legal obligation only to collect checks of our customer if those checks are our bank checks? What is your practice? Do you only collect your checks, your bank's checks? Do you collect other banks' checks also?
Yes, we do, sir.
Right. So, do you agree with me when I say that, may I know your name, please?
Prasanna.
Prasanna, do you agree with me if I say that as a bank, are you a banker?
Yes, sir.
What is your bank?
Commercial bank.
Okay. Prasanna, if I say that you as a commercial bank, you have an obligation to collect checks of your customer if those checks are commercial bank checks. Do you agree with me?
No, sir.
Okay. Right. Why you say you don't agree? Because that the practice is that you collect any check, any bank check received by your customer. That is your practice.
Yes, sir.
That is why you say you can't agree with me.
Yes.
Right. So remember this. If I say that you have a right, or rather you have an obligation to collect any check received by your customer, right?
Yes.
The other side of that statement is that the customer has a right to deposit all the checks that he received to your bank. That is his right. Yes. Under banker customer relationship. But law is very clear. It is not like that. As a bank, we have an obligation to collect checks of our customer, provided that those checks are our bank checks. That is a legal obligation. So that means if it is a commercial bank check, if your customer brings a commercial bank check, you can't say that we are not collecting these checks, that you have to accept it, because it is a legal obligation. However, the practice is that we collect any check, any bank check, if it is our customer. That is, remember, as extra service that we have provided them. That's an extra service. So therefore, the customer can't demand that service because it is provided by us at our discretion. So therefore, we can reject, or we can say that we don't accept or collect other banks checks. That is because it is not a legal obligation, right? But as you know that we can't survive if we say that. So therefore, we have every bank provide this service to the customers. We collect any bank check. That is a banking practice now. Right. That is one point. Then the collection bank has to take extra precautions to safeguard the interests of the true owner if you give this extra service. So remember, if you provide an extra service, that is, you say that we will collect whatever the check that you receive, we will collect. So as a collecting bank, that is an extra service that you provide to your customer or account holder. So then remember, when you give this service, with the service that you have a risk, you get a risk. What is the risk? You have to safeguard the interest of the true owner of the check. I'm repeating again, the bank, the collecting bank, has an obligation to safeguard the interest of the true owner, not the interest of the customer, the interest of the true owner of the check. The true owner of the check may be your customer, may not. Sometimes the true owner may be a third party who is not a customer of your bank. You don't know actually who is the true owner of the check. But your legal obligation is that you have to protect his rights. You have to safeguard his rights or his interest. So that is the risk that you run when you are collecting checks for your customer, right? So we have a misunderstanding or we basically understand wrongfully that we have to protect the interest of our customer. That is the concept that we have. So most of the time we always protect the interest of the bank. Then we try to protect the interest of the customer. But we never think about the interest of the true owner of the instrument or true owner of the check. But when it comes to check, collection of check and payment of check, it's different. The law says that the banker has to safeguard the interest of the true owner. Remember that. So how do we safeguard the interest of the true owner? Since we don't know who is the true owner. So for that, we have a mechanism. We are going to discuss that in our future slides. We'll go to the next one, right? Risk and liability of the collection bank. Listen very carefully. What is the risk that we have when we are collecting checks for the customer? First risk is breach of contract. So in other words, if something goes wrong, what is the liability that we have? To whom that we are liable? Right? Those are the questions that we have to answer. When we are collecting check as a collecting bank for our customer, what is our risk? If something goes wrong, who can claim us damages? To whom we are liable? Those are the things that we are going to discuss now. So first risk is the breach of contract. Breach of contract. What is the contract that can be breached by the collecting bank? So what is the contract that we have? With whom that we have the contract? Remember, the contract is with the customer, with the account holder. Contract is with the account holder. So when a customer open an account, so we have a banker-customer relationship. So in this scenario, who is the customer of HNB? It's A. So between HNB and A, now there is a contract. That contract, we have a special name for that contract. We have discussed previously, right? So that is banker-customer relationship between them. Under the banker-customer relationship, bank has a duty to honor the customer's check and collect checks for and on behalf of the customer. That is the primary obligation or primary duty of a bank if you allow a customer to open a current account. So we say now your customer brings a check given to him by his client or someone to collect to his check, his account, and he present the check to your bank, and he wants to collect the check to his account. Whatever the reason, the bank, without a valid reason, reject or fail to collect the check. Reject or fail to collect the check. What is the liability? Is there any wrong there? Yes, the answer is yes. That's wrong. It is a breach of contract. What is the contract? Bank customer relationship contract has been breached by the bank by not collecting the check on behalf of the customer, because you have you have obliged yourself to collect checks on behalf of the customer. So that is a breach. When we say breach of contract, who can claim damages from the bank? Obviously, the other party of this contract is the customer, the account holder. So the account holder can claim damages from the bank, collecting bank, from you. Your customer can claim damages from you. Then what is the damage? What is the amount of damage that he can ask? Is it the value of the check, or is it something else? Can someone answer? Prasanna, are you there? Commercial bank?
Yeah, I think it's value of the check.
It's the value of the check. Any other person have any other answer? No one is there? Who agree with that? Value of the check or something else? I would like others also, if they contribute. Yeah. Anyone else can answer? Okay, no one. Right. Okay. You are Prasanna, no?
Yes,
Commercial
sir.
bank?
Yes.
Prasanna, actually, it's not value of the check, right? Damages is something different. Damages, we say now check is for 10,000 rupees. We'll say so. Damages could be 10 million. Example, right? We say this customer brings a check and he want to deposit that check to his account. We say that money is to pay a bid, auction bid or something, or government tax or something like that. Bank erroneously didn't collect the check. As a result of that, A couldn't pay the bid or advance or whatever. Because of that, he lost the opportunity, business opportunity, right? So then customer can claim from the bank not the amount of the check, but the actual monetary loss that he suffered as a result of this default by the bank. So therefore, that you have to be very careful when you are collecting the checks, that you have to remember, right? Without any valid reason, that you can't reject or you can't refuse collecting of check on behalf of the customer because you have a contract with him. So that is with regard to the breach of contract. Clear, Prasanna? Are you clear?
I clear.
Right. Others also, if you have any questions that you can ask, but I can't hear any response from others. But I would like others also, if they can respond, then I have idea whether you have understood or not. Right. So the next one that we are going to discuss is called conversion. Conversion. The other risk that we run as a collecting bank, right? Conversion. What is that? Conversion, I will explain. Can you see the board clearly? Okay. We say we have HNB here. They have a customer A who issue a check to B. We negotiate the check to C, right? And the check is stolen by D, and D negotiated the check to E. E is a customer of commercial bank, deposited the check to his account, presented the check for the payment. HNB paid the money to commercial bank, money credited to E's account. Prasanna, can you see this?
Yes, I can see.
Right. Okay. Now, Prasanna, so I will communicate with you, right? Prasanna, looking at this picture, tell me who is the true owner of the check. If I give you a hint, true owner is the person who is eligible or who is entitled to get the money of the check.
I think it's E because check was negotiated to him. So
Right. You say E. Right? Okay. Now we'll see again, right? Check is issued by A and it is issued to B. B negotiated the bill or the check to C. Up to this point, all the transactions are legal. Do you agree with me?
yes.
Right. Then afterwards, what happened? So the check was stolen by D. Right? That transaction is not legally valid. Do you agree with me?
Yes, sir. Yes.
Yes. So D has no title. Do you agree with me?
Yes, because it's a stolen check.
It's a stolen check. So then, do you agree with me that D can't negotiate the check to E?
Yes.
So this then has no value. Now tell me who is the true owner.
True owner is C.
C. Very good. Here the true owner is C. True owner. Now, who true owner? Then again, I'm telling you, true owner is the person who is entitled to get the money. If C is the person who is entitled to get the money. If C is entitled to get the money, no one else has a right to get the money. Do you agree with me? Prasanna?
Legally, is C, but as holder, he can he's entitled that amount, no? Receive that amount.
Who is entitled to get the money legally?
Legally C.
C. Okay, right. Is there any other way that any person can get the money? If it is legal, right? Legally, C is entitled to get the money.
Yes.
No one else. Okay, Prasanna?
Okay.
Right? If someone else has taken the money, that is not illegal then. Do you agree with me?
No, he has no right to receive that amount there.
So no one else has a right to receive the money. Clear? Do you agree with me?
Yes.
Because it's very difficult to, agree the bankers. Right? Because their practice is different. Right? So they don't normally agree with me when I say this. Right? C is the true owner. C is the person entitled to get the money. No one else has a right to get the money of the check. Now, who has taken the money?
E.
E has taken the money. So, do you agree that the money has been paid, or the value of the check has been paid to somebody else who is not the owner?
It's paid to the holder, no?
It is paid to the holder. The E also a holder, no? At what time? Right? At one time, D was also a holder.
Holder, yes.
Right? Then it was negotiated to E. E also a holder. Check has been paid to a holder. That is correct. My question is very simple. My question is, do you agree that the check has been paid to a wrong party? Prasanna, what do you say?
Even though C is legally entitled to receive the rightful owner, since the negotiability of check, let's say now, if he has received the check without noticing the prior defects in the title, that's because he had a defective title, no?
Yes.
So if he has received that check without noticing that defective title, he is entitled to receive the funds, isn't it?
So you are talking about the holder in due course.
Yes.
Right? So because of that, he is entitled to receive the money. No, it is not that, right? We'll talk about the holder in due course later. If the check is paid to a holder in due course, the bank has no legal obligation. Right? Bank has no legal obligation if it is paid to a holder in due course. Right? Prasanna?
Okay.
Right. So for the moment, just forget about the holder in due course and the bank's liability. For the moment, okay?
Okay.
So just forget about that and tell me, do you agree that the money has been paid to a wrong party on the face of this scenario? The story is this. True owner is C. From true owner, the C, the title has not passed to D.
Right, that's right. Yes.
Then D has no title to pass to E. That is also you agreed on?
Yes, yes.
Right? So then E has no title to the check. That is also correct now?
Yes.
So then E may be an innocent person, may be a holder in due course, but he has deposited the check and the money has been paid to E, not to C. right?
Okay.
In other words, the money had been paid to a third party, not to the true owner. Do you
Yes.
agree with that?
Yeah, that's right.
That's right. Right? So, in this case, this is a wrong. The payment is wrong. Do you agree with that?
That's right. It's conversion, isn't it?
It conversion, right? It is called conversion because the money should go to C. Money should go to C, but actually the money has now gone to E, who has no title to the check. So therefore, this is called conversion. Conversion is a offense or is a wrong committed by the collecting bank. Collecting bank. Clear? Right. Now, when it is conversion, the question is, as a collecting bank, to whom we are responsible? Prasanna, to whom we are responsible now?
We are
Or in
responsible to
other,
see. See.
huh?
We are
See,
responsible. Yes.
we are responsible as a collecting bank. We are responsible to safeguard the interest of the true owner. That is what we learned previously. So therefore, if it is conversion, right? If it is conversion, the true owner can sue the collecting bank because the collecting bank is responsible or has to safeguard the interest of the true owner. So this is called conversion. So conversion is, the interpretation is given here, the interference in depriving the true owner from receiving the benefit of the instrument. That is called conversion. So what you have to remember here is, if it is a conversion, collecting bank is responsible, not the paying bank. Collecting bank is responsible. The collecting bank is responsible for the true owner. For the true owner. So therefore, the true owner can sue the collecting bank and can recover the value of the check. The value of the check. Clear? Prasad, are you clear?
I am. Yes, I am clear.
Yes. Okay. Then the liability on the conversion, next slide, where the collecting bank received proceeds of a check for a customer who has no title to the check. Here the collecting bank has received funds from the paying bank on behalf of the customer. This customer does not have a title to the check. The bank will be doing something which is inconsistent with the right of the true owner. The actual owner of the check, who is entitled to get the money, will not get the money. The other party will get the money. So therefore, it is called act of conversion. Then what is the liability? A banker who collects a check for the customer who has no title to the check is liable to the true owner of the check for the conversion, and money had been received. So the bank has to pay the value of the check to the true owner. Then what is the remedy available to the bank? The remedy available to the bank is, the bank first, that he has to satisfy the true owner by paying the value of the check, and the collecting bank can recover the money from the customer who received the funds, because he is not entitled to the money that he received as on the mistaken payment. So that is the remedy available to the collecting bank. Then we'll go to the next one. The true owner's remedies against the collecting bank. What are the remedies available to the true owner against the collecting bank when it is conversion? The true owner of a check can sue the collecting bank, 1, for the damages on conversion, 2, action for the money, that is the value of the check. So the true owner can ask both the value of the the check. Not only that, if there is any damage, financial damage to the true owner, so that damage also can recover from the collecting bank. That is the liability. Right. Then we'll go to the next one. Statutory protection to the collecting bank. What is the statutory protection? Okay. Now the collecting bank doesn't know about this thing, this defect of title, right? They are actually innocent bank, right? They are performing their duties towards their customer by collecting bank, as a collecting bank. Because in one hand, the bank has an agreement with the customer to collect the checks. When the check is presented, the bank has no idea whether this check is a stolen check or whatever, right? So therefore, in one hand, the banks is in a danger situation. So in this kind of situation, what is the remedy, or what are the remedies available to the collecting bank to safeguard the interest? Section 82 of the Bills of Exchange Ordinance uh, is the protection given to the collecting bank. I am telling again, I'm stressing this. Section 82 of the Bills of Exchange Ordinance is only a protection given to the bank. Remember that, all the bankers, you must remember that it's only a protection. When we say protection, a protection you use to protect yourself when others attack you. Right? Think you go to a battle armed with a sword and a shield, right? You have a sword in your hand, in the other hand you have a shield, right? When you go to battle, you fight with the sword, but you don't fight with you don't hit with the shield. So when others hit you, you use the shield to cover yourself. So this section 82 of Bills of Exchange Ordinance is only a shield given to you, right? So don't think it is a sword that you can attack your customer or attack the true owner. It is not the case, right? Only a shield. Remember that, a protection. So what is the protection that you have been given as a collecting bank? Section 82 of the Bills of Exchange Ordinance says, if the collecting bank has received the money for the customer, if you have collected the check and received money for the customer, your customer, two conditions: in good faith, without any negligence, right? If you have collected the check and paid the collect and received the money from the paying bank for your customer in good faith and without negligence, then the bank has no liability towards the true owner. So that means the true owner has to forget about the bank and has to go behind the person who received the money, right? So C has to then file action against C, not against the bank, right? So then that is the protection that you have. Protection that you have to prove in courts, that you have to remember. So in a case like this, what will happen? C will file action against the commercial bank and also will make a party. E also a party to the case, and C will claim money from the bank. So then what is your answer or your defense in the case? Your defense, right? If you know that C is the true owner, you can't say that we have all the right to pay the money to the customer, E, because it's wrong. Payment is wrong. Obviously, the principle is very clear that we have no right to pay the money to the account holder because true owner is somebody else. So in a situation like this, so now C is attacking us. C says that you have done wrong. So what is our protection? We don't go to fight with him. We don't throw our sword to him. So what we do is we take the protection. We take section 82 protection. Section 82 protection says we did this transaction in good faith and without any negligence and paid our customer. So therefore, we are not liable. So you go behind the customer, the person who received the money, and recover your money. That is our argument or our protection in courts. So when we say that we are taking the protection of section 82, that we have to prove it in courts. That two things that you have to prove. What is that? The first one is that you did all these transactions, the collecting money, collecting checks, and collection of money in good faith. That means honestly, without any partial or without any intention to give a benefit to your customer or somebody else in good faith. Second one, without any negligence. We were not negligence at the time of collecting the check and also at the time of paying the money to the customer's account. That those things that we have to prove. Two things that you have to prove as a bank. Right. So when you prove this, when you have to prove this without negligence and good faith, it is easy to prove the first part, good faith. Because as bank, we always, most of the time, we act in good faith. Good faith means with good intention. Normally, we don't have a bad intention. We don't have an intention to seize money and pay to E. That is not our intention. We don't know actually who C is. Right? We honestly believe the true owner of the check is E. Right? And he brings the check and he is entitled to the value of the check. So therefore, we honestly believe and we collect the check and we pay. So there's no bad intention. Right? If you know that the true owner of the check is C and it is being stolen, right? And it is now if you are collecting, still knowing that fact, if you are collecting, there's no good faith then you can't take the protection, because the first element itself shows that you are not eligible for the protection because you are not acted in good faith. Right? So in a case like this, it is easy to prove the first part. Good faith we can prove that we never knows that it was stolen check, and we never had the intention to help E in the cost of C. That we can prove. The question is the second part. Both parts that you have to prove without negligence and in good faith and without negligence. Second part is the most difficult part to prove. That is negligence, without negligence. So we'll see why I say it is difficult to prove in courts, because that we sometimes forget or we don't take much attention to follow procedures, right? So because of that, there can be negligence from the bank side, right? When it comes to the negligence part, when we have to prove that we were not negligent, that we have to prove, or there is a test in courts. So that test has two parts. The first part is that the bank has to prove that they were not negligent when they opening the account. Now we have opened the account say 10 years back, and we are collecting checks today, right? If something goes wrong, the test is that the court will check before 10 years ago when you open the account for the customer, whether you have done any negligence. If it is so, you are negligent today. So that is one thing. The other part that we have to prove is the bank, the court, the second part of the test is whether the bank has been careless, directly careless when they collecting checks. Those two elements that we have to prove in courts, that we have to prove we were not negligent at the time of opening the account, and we were not negligent at the time of we collecting the checks. These two parts that we have to prove in courts, right? Next, we'll see some acts of negligence commonly committed by bankers normally goes against us in courts, right? First one, as I told you that we in courts that we have to prove that we were not negligent at the time of opening the account. So, but in certain cases we have faced, I have seen, right? We have not followed the procedures when we open accounts for customers. The formalities are there, procedures are there, right? Written procedures are there, guidelines given, but the bank officers, bank staff forget, or sometimes they don't bother to follow the procedures and formalities at the time of opening the account. For example, failure to obtain references and introductions when we open a current account. Failure to obtain name of the employee. For example, we say the customer individual customer open an account, current accounts with a bank, right? So you have to get the employer's details. That is a requirement. If you fail to do that, so if something goes wrong, right? For example, we say customer brings a check from a company that is his employee company. Those details are not available with you in your bank because that you have not obtained the employee's information. So then the check is written in the name of this customer and deposit that checks to this account and get money. So then the next day company claims that there was a fraud done by this customer, and so now they are claiming the bank. So in a situation like that, it is very clear negligence because the bank has not obtained the information of the employer. If you would have taken this information, then you know that there is a fiduciary relationship between the account holder and the company, employer company. So therefore, you will be much vigilant when you are collecting the check. Now, because those information are not there, not available with the bank, you have no chance to check with the company. So that is a clear negligence. Then the next one, failure to make inquiry when there is a fiduciary relationship between the customer and the drawer or the payee. Right? Example I have given here, the company official and the company, a partner and a partnership, employer, employee, director and a company. Now, for example, we say the customer brings a check written in favor of him issued by his employee company, right? In a situation like that, if you have this information with you, then you know there is a fiduciary relationship between these two parties, right? So then what is your duty as a collecting bank? Before you collect, at the time of you collecting the check, you have to make an inquiry. You have to make a query. You have to ask from the customer for what purpose that you have got this check from your employee. The customer says, this is my bonus for the new year bonus. So that answer may be wrong, false answer, right? That is a different matter. You don't want to be an investigator. You don't want to be a CID officer. You don't have to go behind every person and inquire. But when you see a fiduciary relationship, that you have to make an inquiry. So if you are not satisfied with the answer given by the customer, so then your next duty is to inquire from the company to see whether the check actually has been given to the customer, or whether it's a check, whether there are any forgery involved in the check. So because as a collecting bank, your duty is to protect the rights of the true owner. That is, when you have a fiduciary relation, when you see a fiduciary relationship between the account holder and the paying party. Then next one, failure to make inquiry when the surrounding circumstances of collection appears to be unusual. What is that? Now think a situation like this. There's a customer, he has a current account. So you have taken the information of the customer at the time of opening the account. So he has given information that he is employed in a bank or rather a company, that his salary is 50,000 per month. So this is his salary account that he brings the money. So every month he brings a check from this company of 50,000. You know, that is his salary. So he deposits this money to his account. So 1 month, we say in December, he brings a check. 25th of 26th of December, he brings a check issued by the company. At this time, the check's value of the check is say 250,000. 250,000. Now, what is the situation? Now, the check, you are the collecting bank. When you see the check, you see the surrounding circumstances of the check is now different. All this time, every month he brings 50,000 check, but this month he has brought a check worth of 250,000. As a prudent banker, you should have suspect this check. So in a situation like this, what do you have to do? You have to inquire from the customer, because the surrounding circumstances of the check is different now. So you have to satisfy yourself before you collect. So he may give an answer, right? This is my bonus or whatever, or he may say that I got a loan from my bank or whatever, my company. That you have to inquire and you have to satisfy yourself before you collect the check. Otherwise, what will happen? It could be a clear negligence. Then if this transaction lead to a conversion, that you can't take the protection of section 82 of the Bills of Exchange Ordinance, because you have not done your job without negligence. So then some acts of negligence I have given in this slide also. So official checks not to be collected to the personal account. That means, so director of a company, the company issue a check to the director and the director collect the check to his personal account. The bank accept. Right. Should not do that. So we learn, but sometimes we see the bank, because of the relationship or whatever, has collected the company check to the director's personal account. Then corporate checks are not to be collected to the personal accounts. That is other thing that you have to remember. There is a case also, Underwood versus Bank of Liverpool. The company check has issued by the company has been collected to a personal account of an employee. So later on, it was revealed that it was a forged check So therefore the bank was liable for the collection of that check. Then the principal's check not to be collected to the personal account of the agent. Right, that agent word is not there, that you have to note down that principal and agent relationship. When there is a principal and agent relationship, the principal's checks not to be collected to the personal account of the agent. So for example, if I have an account, I can appoint an agent to carry out my transactions. So what the agent's duty is that he has to collect the checks from my customers and has to deposit that checks to my account, the principal's account, not to his account. So what happened in this case, BOC versus Kulatilaka, this agent collected the checks for the company, or the agent, rather the company, the principal company, and the agent deposited those checks to his account. Bank collected those to the account of the agent, and agent took the money of the check. So ultimately, the principal filed action against the bank, not against the agent. So because it's a clear negligence, then the customer was successful and he got the money in this case. Then other one is the partnership check should not pay or should not collect to the personal account of the partners. That should be collected to the partnership account, not to the partner's personal account. Again, there is a case, Baker versus Barclays Bank is the case. That checks for joint pay is not to be collected to the single payee account. We say now there are two customers. There are two customers who carrying a joint account, A and B, right? So check is written to the joint account payee check. It's only collected to that check, but however, the bank has collected the check to a single person's account. So that is also wrong, a negligence. So that is the case. Moser versus Commercial Banking Company of Sydney. In this matter, that's what happened. So those are the legal principles that you have to remember when you collect checks for your customers. So if you have any questions from collecting of checks or whatever that from whatever we discuss, you can ask questions. Otherwise, we'll go to the payment of checks. You have any questions?
Yes, I have a question.
Yes.
When a check is drawn in favor of a partnership, we generally collect the check to a partner's personal account after obtaining the consent of all the partners.
Yes.
Is there any legal concern there, sir?
No, that is now. If you don't take the consent of the other partners, then you are in trouble.
Yes.
Right? If you take the consent of the other partners, your practice is wrong. But the problem is that the other partners can't take any action against you because they have given consent. Because of that, you are protected. Actually speaking, the correct procedure is that you have to collect the checks to the partnership account, not to the account of the personal account of the partner. The same principle apply when it comes to joint account, right? If the check is written in favor of the joint account holders, one joint holder can give the consent to the check to collect the check to a personal account. That consent, if that consent is given, that is okay because he can't challenge later. But technically speaking, it has to be collected to the joint account. Right.
And even we receive a request from the directors of companies to collect the check drawn in favor of the company to collect their director's personal account. Generally, we don't entertain such requests because even after obtaining consent, we generally do not entertain.
Yeah, you should not. May I know your name, please?
Prasanna.
Again, Prasanna from Commercial Bank.
Yes.
Right. Prasanna, what you said is correct. Now, in this case, if it is a company, of course, then it's a different matter, not like partnership, right? Company is a legal entity, separate entity, right? If company check is collected to a director's account with the consent of the director, it is wrong, because director can't request or give consent on behalf of the company. The company has to give the consent. So company to give consent, company has to pass a resolution. So therefore, it is anyway wrong. So what you are practicing is correct. You should not collect a company check, or rather a check written in favor of the company to a director's account. There can be several directors, but still, even all the directors give the consent, you can't collect that check to a director's account unless the company has passed a resolution and authorize such transaction. Okay, Prasanna?
Okay, thank you. There are another practical situation we have. Now, let's say it's a joint account with the parties A and B. So, if the check drawn in favor of party A, and the B comes with that check and deposit their joint account, later can A claim from the bank?
Again, can you come again? The joint account is there.
Yeah, A and B are the joint account holders.
Joint account, okay.
So B comes with a check drawn in favor of A.
B comes with a check drawn in favor of A and given by some third party.
Yes, draw is a third party. So they deposit that check to their joint account.
Okay, right. Without the consent of the payee, you deposit that check to the joint account.
Joint account of A and B.
Yes. Okay.
So can A claim if there's any later? Can A claim from the bank if there's in dispute likewise?
Yes. Yes. Because it's like this. Now it is if it is not a joint, if it is not written under joint names, it's the payee is A.
Yes, that's right.
Right, payee is A. So the true owner of the check is actually A. So that money is A's personal money. So if it is deposited to B, A and B's joint account, once you put the money into the joint account, what is the situation? Situation is A and B are equally, or rather 100% entitled for the entire money of the account.
That's right.
It is not 50-50. Right? So therefore, even B can take all the money of the account. So therefore, that collection is wrong then. So then we can claim that money from the bank.
That means you have to obtain the consent of A.
You have to obtain the consent, request from A to deposit that money to the joint account. Yes. Okay. Any other questions?
Thank you, sir.
Right. Okay. Then we'll go to the payment of checks. Right. Payment of checks. That is from this side. HNB. Now, when the check is collected and the check is presented to the HNB debit the customer's account and send the money to the collecting bank to pay to their customer. So that part, right? Sometimes for our customers, we pay checks, right? So when we are acting as a paying bank, what are the liabilities, or what are the duties as a paying bank? That we are going to discuss now. Right. Payment of a check. The bank is bound to honor the customer's check when the checks, when they duly presented for the payment, and if they are duly filled in the proper form. So this is the first thing that you have to remember. The bank is obliged to pay, or has a duty to pay the check, if it is duly presented for the payment. and if it is duly filled in a proper form. These two conditions that you have to remember. Has a duty. So what do you mean by duly presented? Duly presented means the customer has to present the check as per the law to the same bank, same branch during the banking hours. Right? That is the first condition. So, for example, we say now the account is maintained at Borella branch and the check is presented to Anuradhapura branch. What is our practice? Do we pay? The answer is yes, we pay. But again, remember that is an additional service that we provide. So therefore, it is not a duty, not as a duty. But we say the account is maintained at Borella branch and the check also presented to the Borella branch. So then it's a duty of the bank to pay the check because it is presented to the same branch where the account is maintained. That is a different situation, right? And if it is duly filled in the proper form, if the check is duly filled and if it is in the proper form that we provided to the customer, that is a valid check. So therefore, we are obliged to pay, right? Then bank should not honor the check, one, when the customer is deceased or bankrupt. First condition. Second one, when the customer has stopped the payment after issuing the check, before it pay, customer stop. When no sufficient funds available in the account. Next one, when there is a legal bar or when the bank has the knowledge of fraud or breach of trust. In a situation like this, the paying bank should not pay the check, right? So these things that you have to remember. When the customer is deceased, bank has no right to debit the customer's account. The account comes freeze or cease. No transaction can be done or even bankrupt. When the customer has stopped the payment, that means countermanded the check, bank cannot pay, should not pay. When there is no sufficient funds available in the account, bank has a discretion, right? Bank normally we return the check, or depending on the customer's relationship and his previous transaction, bank can decide to grant him an overdraft facility. That bank's discretion and the risk also with the bank. When there is a legal bar, what is the legal bar that we are talking about? There can be a court order seizing the account, or there can be a enjoining order against the bank by paying the particular check, or there can be a order issued by the court, especially by the magistrate court, by stopping the payment of the check. If there is a criminal activity or any illegal activities involved, that could happen. Apart from that, if the banker has any knowledge of fraud or breach of trust, in a situation like that also, that bank should not pay the check. For example, we say now we know that a person, the account holder, is accountant of a company, and that you have the knowledge that there was a huge fraud has happened in that company, and some of the employees also engage in the fraud of that company. So this person is the accountant of that company. He now brings a check of the company, and in a situation like that, you have a knowledge of fraud or breach of trust. In a situation like that, you should not pay the check. You have to get the clarification or confirmation from the company account holder. Right. Even though we say that we have to take precautions, we have to take all the measures before we pay, certain situations that we pay checks erroneously or mistakenly. So that is called mistaken payment. The mistaken payment can be categorized into two. First one, the first method of mistaken payment is due to mistake of facts. The other category is the payment made due to mistaken of law, right? Mistake of law or mistake of facts. For example, we say, uh, what is mistake of facts? Now we uh, take a situation like this. We say the customer has issued the check, or rather, customer is a company, and the company has given authority to authorized signatory to issue checks. There are two authorized signatories. Authorized signatory A has given an authority to issue checks for 100,000. 100,000 and above checks has to be signed by the authorized signatory B. Checks comes and you see the check, and the check value of the check is 150,000. A has signed, but mistaken of facts that you think that A has the authority to up to 200,000, and because of that, believing that the A has authority to sign such check, the banker pay. That is a mistaken of facts. You have mistakenly identified that the person A has authority to pay or sign. Or another situation that we say, now A has A is the payee of the check, right? A person brings a check. We say it's a cash. We say it's a payee check. So he represents himself as A, and you, after satisfy yourself that you pay the money to the holder. So you believe that holder is A, but later on you find that he has impersonate himself as A by producing a forged identity card. What is that? The payment is a mistaken payment. What is the mistake that you have done? That you have mistakenly identified somebody else, we say B, as A. So money has gone to B. Actually, the money should go to A. It's a mistaken payment. Then the second category is the mistaken of law. Example, we say it's a post-dated check. Check is presented for the payment. You believe under the law, the bank can pay the check, post-dated check before the date, and bank has no liability if it is paid. But actual law position is that you can pay, that is correct. But if you pay, it's a risk of the bank. The bank has to bear the loss, right? So believing that you have no obligation and you have all the right to pay, you pay. That is misunderstand of law or mistaken of law. So these two type of payments is called mistaken payment. So you think about any payment that you made mistakenly coming under either one of these categories. Either it's a mistake of facts, or if it is or either it's a mistake of, right? So these are the type of mistaken payments that we made. So what next one? What is the risk or what is the liability of the paying bank on a mistaken payment? First one, we'll discuss the payment without mandate. Payment without mandate. If the check is not paid to the genuine payee, then the check is not paid to the order of the designated person. Therefore, the check is not discharged. Now, for example, we say a check is written in favor of Nimal Pereira. The payee is Nimal Pereira. So, designated person is the Nimal Pereira. The drover's intention to pay the money to Nimal Pereira. Check will be discharged if we pay money to Nimal Pereira. If it is not paid to Nimal Pereira, check is not discharged, and the drover's intention is not fulfilled, because drover wants to pay the money to Nimal Pereira, but bank has paid money to somebody else. For example, we say Sunil Pereira has somehow taken the check and has created a forged identity card by replacing the photograph of Sunil Pereira instead of Nimal Pereira's photo, and brings the check with the identity card. And you check the identity card and you see the picture, the person in front of you is the same person, and the details of the check, or rather the check is tallied with the details given in the identity card. Name, identity card number, address, everything is P.L. Pereira's details, which tallies with the check details, payee's details. So you are satisfied. The person in front of you is P.L. Pereira. Actually, he is Sunil Pereira. So you pay the money. You pay the money. The money is paid to not to P.L. Pereira. Actually, it is Nimal Pereira rather paid to Sunil Pereira. So Sunil Pereira has taken the money. Sunil Pereira is not the designated person in the check. So therefore, check is not discharged. Check is not discharged. Right? And it is a wrong payment, and it's a payment made without the mandate, against the will of the drover. Drover's will, drover's intention to pay the money to Nimal Pereira, but money has paid to Sunil Pereira. So therefore, check is not discharged. Then what is the liability? If the bank pays the checks other than the true owner, the bank is liable to the true owner, unable to debit the customer's account. This is the liability. So if you have paid the money to a wrong party, the bank has no right to debit the customer's account. So in other words, if customers say, no, you have to return my money, the bank immediately has to return the money to the customer's account again. And what is the remedy available to the bank? Bank has to go behind the person who got the money and has to recover that money from the person who received. Right. The bank is liable to the true owner of the check. So that means the check true owner can claim the money from the bank. So in both ways, the bank is liable. To the customer, that you are liable to return the money. To the true owner, that you are liable for the value of the check. That you have to remember as a paying bank. Then the second type is forged or unauthorized signature. If the bank, you may remember section 24 of the Bills of Exchange Ordinance says, if the check signature of the check is forged, the check is only inoperative. That means there is no check. What is the situation if you pay a forged signature check with a forged signature? Bank has no right to debit the customer's account because there is no check. But the customer is stopped from setting. When you say the bank has no right to debit the customer's account, you have already paid the check. So therefore, that you have to return the money to the customer's account. And you have to go behind the person who got the money. But there is an exception, right? But the customer is stopped from setting up a forgery or lack of authority, A, as a result of express or implied representation. So it's like this. If we say now the company, account holder is a company, and the company has given authority to a person to issue checks up to a certain limit. That person has exceeded the limit and has issued several checks, but the company knows that he has exceeded the limit, but company represent to the bank that he has a right to issue checks. So in other words, company accept the transaction. So in a situation like that, the company is stopped. The singular word that we use for stopped is pratibandhanaya, right? You are stopped from denying once you accept the situation. So that is called a stop. So once, if the company has represented the bank that the person has authority to issue checks, then later on company can't say that that person had not the authority, so therefore bank can't pay, the bank has to return the money. That company cannot say that. The case is Brown versus Westminster Bank. Then the second one, as a result of breach of customer's duty. That is, the case is given here. So Greenwood versus Martin's case, that you may remember this case. Customer has a duty towards the bank, towards the paying bank. If there is a forgery, if customer knows about the forgery, the customer has a duty to inform the bank about the forgery at the first instance that he that the knowledge of the forgery came to his attention. Again, when there is a forgery happen, when it comes to the knowledge of the customer has a duty. It's a duty under the banker-customer relationship. Customer has a duty to inform the bank, to inform the paying bank at the first instance that he came to the knowledge, that he got the knowledge of the fraud. So what happens if we don't do that? That is a breach of duty. So then thereafter, if bank has paid the money on the forged check, the customer, that is the account holder, cannot do anything. No liability on the bank. Customer or the account holder is stopped from denying that fact. So therefore, that you have to remember, unauthorized signature, bank has no right to debit the customer's account, has to return the money, but there are exceptions, 2 exceptions are there. Then altered checks.
So can I have a question?
Yes, please.
So most of the instances where customer may claim that his signature has been forged, and customer doesn't have the duty of safekeeping of checkbooks, because sometimes his employee may forge his signature and check may be in cash. So if you are not, if the customer is not mind enough to safekeeping of the checkbook, is the bank liable?
No, the case is Colonnava Urban Council versus Bank of Ceylon. In that matter, it was discussed. It is not the duty of the customer to keep the checkbook in safe custody. There's no obligation like that. Or any forge done by the staff or of the customer is, if it is not with the knowledge of the customer, he is not bound. The section that 24 of that is forged signature is what we call it strict liability of the bank, on the bank rather. What do you mean by strict liability? If the signature is forged, right, there's no any other remedies, the bank has to return the money to the customer's account. Only two situations that you can put the blame on the customer. Those are Greenwood principle and Macmillan principle. Have we discussed this Greenwood and Macmillan before?
Yeah, last time we discussed that.
Yes, so we discussed now. So only those two circumstances only that bank can put the liability on the customer. Otherwise, bank has to return the money. Clear?
Okay, sir. Okay, it's clear.
Right, right. So then altered checks. What is altered checks? If a check is altered, it is void. Altered means we talk about the materially altered checks. So you know the date, the value of the check, the signature. If it is signature altered, that is a forgery. Likewise, there can be materially alterations in a check. If it is materially altered, it is considered the check is considered as void check or an invalid check. Then what is the situation if you have paid a check like that, altered check? The bank honors a check which has been materially altered, has no right to debit the customer's account. So that means the bank has to return the money to the customer's account, and you have to go behind the person who received the money. The case is Yorkshire Bank versus Lloyd Bank Limited. Lloyd Bank Limited. In that matter, it was decided that altered checks are not valid. Bank cannot pay. Bank cannot rather debit the customer's account. Then protection on the payment of the check. Paying banks protection. There are two protections. First one is the estoppel. We discussed the customer is stopped from relying on the alterations if if it was facilitated by the way of show the check. Case is Macmillan that you may remember. The customer wrote a check very negligent manner, so that facilitate for a forgery. So in a situation like that, the customer is stopped. Customer is stopped from denying the liability, so he has to take the liability. That is called Macmillan duty. The other one is the payment due to a holder in due course. This is Prasanna asked before, right? What will happen if we pay the check to a holder in due course? In this situation, if he is a holder in due course, this is a protection given to the paying bank, right? So paying bank, if the bank has made the payment to the holder in due course, the bank is entitled to debit the customer's account, so he can take the money from the customer's account. So therefore, paying bank has no liability if it is paid to a holder in due course. Are you clear, Prasanna?
I'm clear. I'm
Right.
clear.
Okay. That is with regard to the paying bank, not with regard to the collecting bank. Okay. Right. Then ratification. Ratification comes with the unauthorized or unauthorized signatures, right? Where the agent exceeds his authority and drawing a check, his act may be ratified or adopted by the principal. Ratification, the Sinhala word that we use for ratification is appara anumitiya. It's appara anumitiya. Rectify after or accept after. Right. So what has happened in this situation, in this case, there is an authorized signatory. He has given authority to up to a limit, but this authorized agent or authorized signatory exceed his limit and issue checks. Then the principal, that is the account holder, ratify that act later. Ratify means that the account holder accept. Okay, even though he has exceeded the limit, I accept this check. So he give his consent to pay. Once he accept or ratify the signature, unauthorized signature, later on, he can't claim that money from the bank. That is called ratification. When the customer is precluded from the disputing the paying bank bank's right to debit the customer's account. That means the customer then can't later on say the the signature, the authorized signatory has exceeded the limit, therefore the check is not valid, you have to return my money. That argument that the account holder cannot take before, because the signature ratified. The case is London International Trust Limited versus Barclays Bank. So this case that you can remember for that. Then the banker's remedy for the payment done mistaken of facts of mistaken of law. Now we discuss about the mistaken payment, mistaken of fact. So mistaken of law, as a result of mistaken of law or as a result of mistaken of facts, we pay money. We pay money to a wrong party. So it is a mistaken payment. So if we pay money to a wrong party, what is our liability? The first liability that you remember, that immediately we have to return the money to the customer's account. So we have to return the money to the customer's account, paying back. So once we return the money to the customer's account, remember now we have already paid money. From whom we are going to recover the money? And on what basis that we can recover the money? So those are the things now we are going to discuss, right? What is the remedy available to the bank to recover the money paid mistakenly? So the bank's remedy is to seek recovery of money from the recipient of the money, that is the value of the check, on unjust enrichment. That is the word or the principle that we use to recover the money mistakenly paid to a wrong party. What do you mean by unjust enrichment? Unjust enrichment means one person enrich himself unjustly. That means that I received money which is not belongs to me, which should not be should pay to me. So that is unjust enrichment. So therefore, I am not entitled for that money. So the person who paid the money has a right to claim that money from me on the basis of unjust enrichment. So the paying bank has to recover that money from the person who paid, from the person who received the money, who is not entitled for the money, on the basis of unjust enrichment. That is the remedy available for the paying bank. So the collection of checks and paying of checks is over. If you have any questions from there, that you can ask now. Any questions?
Section 82 generally applies for current account. When obtaining introduction, that's a cover given to the bankers. But most of the time, customers comes with checks, and they request to deposit those checks to a savings account, newly open savings account. So, is there any bearing on the bank, like conversion risk, likewise?
Can you again Can you again say your question? Because now you say customer is a current account holder. He brings
generally the section 82 that applies for current account holders. No, just for obtaining introductions. Interaction, but most of the time, customer they comes and request to deposit checks to savings account. If they doesn't have account, they request to open up a new savings account, and deposit the check. So there's any concern or conversion risk to the bank in such situations?
It's like this. Section 82 says that bank has to collect the check or pay the check without negligence, in good faith.
Yes.
Right? Those are the two conditions. Now, when a customer requests you to deposit the check to a savings account, and if he doesn't have if he has a current account and if he's not depositing the current account, and if he asks to deposit that to a savings account, you have to make a inquiry. and ask why you are not depositing this check to a current account, and why do you want to open a new account and deposit this to a savings account. So you have to see what is the answer that he provides. So if you are satisfied with uh, the answer he provides, that you can go ahead with that, because what expected from you as a banker, two things, right? To get the protection, you have to be you have to work with good intention, that is without without any negligence, in good faith. So if you have done that, then you are protected. So that is the condition. So if you have acted negligently, then of course, then you can't take the protection under 82. So my question is, when you open a new account and deposit the checks to that account, do you get any confirmation from the drawer of the check?
Generally, we check the underlying transaction. Like, let's say if a customer doesn't have any sort of relationship with the bank, so if it's a new comes to deposit check to a newly opened account,
Right.
so we generally check the underlying transaction and we
How do you
inquire.
check the underlying transaction?
Like if it's a land transaction, we check the transfer deed. Like
Right. So, right. In a case like that, of course, if it is a one transaction, one-off transaction, of course, then you can check the underlying transaction.
yes.
Or otherwise, it's difficult, no, that you to trace the transaction that occurred.
Yes, most of the time this request comes to savings account, because in
Yes.
current account we don't have that problem, but for savings account they request, because they doesn't have any account for one-off transaction, they come to the bank and we request to open open up a savings account and
Yeah, and they want to
deposit
deposit the money,
yes,
check into the savings account.
savings account, yes, just to clear
Yes.
the check actually. The
Yeah,
purpose
I
is
know
just
that. So if you are satisfied with the transaction, that means that you were not negligence, right? You know that you have you checked with the customer. You know that it is a land transaction or whatever, or maybe a sales of vehicle. The proceed comes as a check. So then you deposit that check to his savings account. So then it is all right. At least you can take the protection of 82.
yes.
So otherwise, it is not advisable to, if it is a complicated transaction, if you can't trace the transaction, should not collect to a savings account.
Yes.
Right.
Generally, that section 82 applies for current account, isn't it? For savings account also, can we obtain that protection?
Yeah, it's a general. Actually, it's a general shield given to the bank. That is the general protection that we take any transaction. But mainly it is applicable to current account because it's about the checks, right? Under the bills of exchange ordinance, under the checks part, this comes section 82. So
Yes.
it is indirectly, it says it is applicable to the current accounts. But when it go to courts, when they test whether the bank has acted without negligence and in good faith. Those are the tests that they normally conduct.
Right.
Okay.
Yes. Thank you, sir.
Right. Okay. Then shall we start the next lesson? Okay. The next one that we are going to discuss is debt recovery process. Have we discussed this before, Prasanna? In our class, did we discuss this before? No.
No, I think so.
Right.
No, we didn't discuss that.
Okay. Right. So this is another the topic that we have to discuss. We have 15 minutes time, so we can start this, and we'll continue on the next week. Debt recovery process. Debt recovery process of a bank is very important thing, that you know that our business is, that you remember, our business is we are lending money, we accept money from the customers or the public, general public, and we lend money on interest. That is our business, banking business. Now, when we say we provide facilities or we provide loans to customers, we have two types of facilities. That is, first type is secured facilities and the other facilities we call unsecured facilities. I have given here some examples for secured facilities and unsecured facilities. So facilities secured by guarantee bonds, FDs, mortgages, that is one type of secured facility. Then the pledge loans. In a pledge, what is the security? Normally, stock. Stock in trade or stock is the security, collateral. In a leasing, vehicle is the collateral. Hire purchase also same, the goods or the commodity or the instrument or the vehicle. Pawning or pawn loans, we have gold articles as a security. Unsecured facility, the casual example, casual overdraft, temporary overdraft, short-term loans, credit cards, these types of lending that we call them unsecured facilities. Unsecured facilities, the risk of recovery is high, so therefore we charge high interest normally for unsecured facilities. Then about the recovery process. Recovery process is important because, for example, we say now we take one transaction. Is our business is we take deposit from the customers and we lend money to the customers and we generate income. We say now we take deposit from a customer. We say we have a customer A who has deposited money in the bank. So we say he deposit 1 million rupees. Or we say he deposit 100 rupees. Right? So then we agree, he put a deposit, fixed deposit, the money 100 rupees he put into a fixed deposit. Bank agreed to pay 10% per annum. So the fixed deposit is for 1 year period. So now we have a liability to pay this rupee 100 plus another 10 rupees as an interest, 110 at the end of the year. Then to pay 110 rupees at the end of the year, we should generate income. We have to generate income. That income should be sufficient to pay 110, recover our cost, pay our staff cost and everything, and also our profit. So that means that we have to generate, we say at least 125 rupees using this 100 rupees. So that is our target or our business. So what do we do? So what the money that deposited by the customer 100 rupees, we lend to another customer as a facility, a loan or overdraft or whatever. We take money from A and we give that money as a lend. We lend that money to the customer B for a higher rate. We agree to pay 10% to the depositor and we lend to the borrower 15%. So if this smoothly happens, this lending business, at the end of the year, we will get 115. 100 loan, that is the capital that we recover 100 plus the interest that agreed, the customer paid 15. So we get 115 rupees. So we have to return 110 to the customer who deposited the money to the depositor. We have 5 rupee margin That is our, we say, income, or that is our income basically. So take this scenario, right? And we can rather we can go ahead with this business as long as customer or the borrower pay the money lent to him as agreed. What will happen if customer or the borrower default? We take money from the public, we agree to pay 10% interest, we lend that 100 rupees to B, the borrower agreed to pay 100 plus 15 rupees at the end of the year. After 6 months, he default. Now we have obligation. We are in trouble. We can't recover the interest and we can't recover the capital also. Because at the end of the year, we are obliged to pay through the depositor. So same principle or same scenario applies to the bank, right? We take one loan, but we take 100 loans, 1,000 loans, billions of loans. The same thing happen. Same thing could happen if we can't recover the money that we lent. So therefore, the bank should have a proper mechanism, efficient mechanism to recover loans. Otherwise, we can't run the business. You know, as bankers, when we lend money, we can't recover 100%. There is always an NPL ratio, right? Non-performing ratio. There is an NPL. So we are trying as banks to keep this NPL as lowest as possible. So that is what we need. So now we'll see what is the procedure, what are the procedures available to the bank to recover these loans. If they go bad, what do you do? How do you recover? That's we are going to discuss. For this lesson, this program, that you have to study special laws introduced to the banks and other institutions to recover loans or lendings. Before that, before we study the special laws, we should have a general knowledge of a normal procedure. If you don't know the normal procedure or general procedure, then it is difficult, or rather no point to study the special laws or special procedures. So therefore, first of all, we'll look into the general procedure, how to recover loan. General procedure to recover loan, bad loans, right? So first, this slide shows how to recover a loan or money, defaulted money, through a court case, right? The normal procedure, known procedure, general procedure is when a customer default, we try to negotiate with him. Our recovery officers go behind him, try to get money. If all efforts fail, then what do? You start legal process, right? This is the process that we normally go through in courts, right? The steps I have given here, 8 steps that are one by one I will explain briefly to you. The first step of a legal action, which is not written here, that is that we send a letter of demand, LOD, letter of demand. The letter of demand, you can note down that the letter of demand normally is sent by a lawyer. So therefore, remember the first step, that we have to send a letter of demand. That is a requirement under the law, because first of all, before we file action, you should have a course of action. Nadu nimitta, course of action. You have, unless you have a course of action, you can't file action in courts. So course of action arise when you demand, if customer refuse to pay, that is a course of action to file action in courts, right? So therefore, first step that you have to do, so banks do, is send a letter of demand to the customer. When we send a letter of demand, in the letter of demand we mention that he has to pay so much of money within normally 14 days. We give him 14 days, reasonable time that we provide him to settle the entire loan and the interest. So if he doesn't pay within 14 days or reject to pay, then we have a course of action. Then what do you do? We file case in courts. Next step is filing of case, legal action in courts. Filing of legal action means that the party who files the legal action in courts is called plaintiff. So we take a bank, a transaction, if customer default, bank file the action. So bank is the plaintiff. So bank, through their lawyer, they file a plaint in courts. I mean, it like that, a plaint in courts, right? Once the plaint is filed by the plaint means that our story, right? Our grievances that we tell to courts. So then we say this. So in the plaint we say that we have granted so much of money. This is the securities provided by the customer. Customer paid only this much. After that he defaulted, and we send a letter of demand. He didn't respect the letter of demand. So therefore we are asking a judgment against the customer, against the borrower, for a value of this much. So that is the basics of the plaint that we put in writing in filing courts. After filing the plaint in courts, the court issue summons to the defendant, that is through the borrower. Serve summons. Summons will be served through a fiscal to the borrower. Once a summons is received by the borrower has to come to courts and file his answer to our plaint. So whatever that he has to say about our complaint, that he has to put into a paper and file through his lawyer. Now once he file his answer in courts, now before the judge there are two things. One is one side from the complaint, one side there is a complaint from the bank. Then the other side there is an answer provided by the defendant or the borrower to the complaint made by the bank. So there are two stories there. So when afterwards, now judge has to decide who is wrong and who is correct and who is wrong. So how does he decide that? For that, he has to he has to take this matter to a trial. So then the next step is the trial. At the trial, so what is the procedure? First, the plaintiff has to start the case. That is the bank. So through bank lawyers, the bank witnesses will have to give evidence and has to produce their documents also. Then afterwards, the defendant's lawyer, that is the borrower's lawyer, can cross-examine the witness, that is the bank officers. So after all the witnesses of the bank given evidence, then defendant can start the case by giving evidence. So afterwards, after hearing both parties, judge pronounces his judgment. Right? We assume that the judgment is given in favor of the bank. So that means the judge has decided the borrower has to pay this much of money to the bank. That is the judgment. So judgment is a paper. So what we have to do after getting the judgment, we need money. We want money to recover the loan and outstandings and expenses. So therefore, the next step is in a money recovery action is called execution of decree. Execution of decree. Execution of decree means uh, the fiscal officer of the courts goes and seize the properties of the borrower. He can seize any property of the borrower except few things. Those are, the fiscal can't seize the clothes of the person, that borrower, and the fiscal can't take the bed of the borrower, or seize the fiscal can't seize any equipment that the borrower used for his livelihood. Like if he's a, say, we're a carpenter, that we can't take the tools that he used for his job. Those things that he can't seize. Other than that, any other thing, household items, any other things that he can, the fiscal can seize. If this borrower is working, is an employee, then the fiscal can seize the salary also. So after seizing the properties, that property will bring into courts, and afterward the fiscal uh, has to auction the goods that he sees. So at the auction, after the auction, the money that he collected from the auction has to deposit in the courts. Afterwards, the plaintiff, that is the bank, can make an application to courts and can release the money and recover the loan and the cost of litigation and other expenses from the money received from the auction. That is the normal money recovery action to recover a loan or money from the borrower who has defaulted. That is the procedure. So this procedure, even though that I have briefly explained you, to get a result from a case like this, to recover a loan, it takes about 3 to 4 years. So 3 to 4 years get a result. So when it comes to recovery, this, you will agree with me, this is not a very speedy method, very effective method, because the banks and other institutions, they want to recover their loans as soon as possible. Because, for example, we say we have lent money to the customer or to the borrower for a 2 years period. So after 6 months, the customer default, right? Customer default. Then we go to courts. Case goes another 2 years. So automatically, then the customer is benefited, because now we get more time to settle, and we are in trouble as a bank because we have to settle our depositors. They will not wait till we recover the money from the borrowers and pay them. We are taking the money from the public on a condition, that is, we are supposed to pay when they demand with interest. We have to pay. So therefore, this mechanism, normal money recovery action, is not an efficient, effective, speedy system or process to recover loans in the banking sector. So therefore, we need a speedy, effective system to recover our loans. So the time is over. So you have any questions from this money recovery action? Anything that I can, if you need any more clarification or anything? Prasanna and others? Can you hear me?
Yes, sir. It's
So
clear.
it's clear.
Yeah.
Right. So then we'll stop at this point. The next day that we will start from mortgage bond action and debt recovery special laws that we are going to discuss. on the next day. So thank you very much for your cooperation. Hope that you properly heard me and also see me. So then we'll meet next week. Thank you.
Thank you.